Welcome to Thinking Like a Lawyer with your hosts Ellie Mistal and Joe Patrice, talking about legal news and pop culture, all while thinking like a lawyer. Here on Legal Talk Network.
Hello all, welcome to another edition of Thinking Like a Lawyer. I'm Joe Patrice of Above the Law. With me, as always, is not Ellie Mistal, but as becoming, as always in 2019, I guess I can say.
Increasingly regularly.
Yes, is Catherine Rubino, also of Above the Law. How are you?
Hey friends, how are you?
I'm good. And we also, of course, we would be remiss not to thank our sponsors from Smith AI. If you don't know Smith AI, they are a virtual receptionist service for lawyers. They have U.S.-based professionals answer your phone and website chats and screen your potential clients and schedule appointments. So schedule a free trial with them by going to smith.ai. So we're here.
Hey, how are you?
I'm good. Last week, you didn't really grasp the format. Do you have anything that you're angry about in particular this week to grind your gears?
Well,
or maybe I should stop trying to make you like another Ellie in my life.
Yeah, I mean, that's fair.
There's probably something disturbing.
We have one Ellie. We have enough Ellies in our lives. But I do find it a little bit frustrating when people assume your availability without actually asking you.
Oh. See,
awkward.
That's not cool. You understand this was an emergency of Ellie's availability. Ellie can't be here. An emergency came
but
up.
It's usually it usually is accompanied by a request, not a demand.
I didn't. No, that was a request. I said my chat to you is. You understand if Ellie's not around, there's a podcast at 3. That is not necessarily a demand. That is an
sound. It does not sound like you're asking me. You're not saying, "Hey, are you available at 3 to cover?" Because, as you know, Ellie has this thing that's come up.
I just informed you of a fact, and you then brought all the baggage that you're carrying.
I can't imagine why I might have baggage with the interaction with Joe Patrice.
See, I am a pleasure to work with, and
is that what you tell yourself?
That's what other people tell me.
Who?
People. Very important people. The best
That's
people.
Amazing. That's amazing. No, but I don't mind covering a podcast. I did have to reschedule other meetings because my life is not just at the whims of Joe Patrice and Ellie Mistal, but fortunately, there are other people I was supposed to meet with where
Well, they're still in another meeting.
So it turns out.
Yeah, so cool. So that's your gear grinding. You're upset about that sort of thing. That's fine.
And I managed to not yell.
Yeah.
See how you can be annoyed about things
and not yell.
and keep your tone appropriate.
Interesting. I don't know as though appropriate is the right term. Like some of the things he discusses are bad enough that it is appropriate to be upset.
Fair, maybe appropriate is the inaccurate word, but
yeah.
You can also express anger and frustration without raising your voice.
Right. Passive aggressiveness. Yeah.
That's not even what I mean. Although in this instance, that is what I use.
Yeah. I mean, as an attorney, you are very well aware of how passive aggressiveness works.
Yeah.
That actually is, for those who are considering entering the big law universe, that is, in many ways, the dominant paradigm in my experience of big law. There are a few screamers, but they're few and far between. There are much more the people who are they're not really mad, they're just disappointed.
So, okay, that's a good question. What, when you were a practicing attorney, or even now, I suppose, was your go-to passive-aggressive email line? Like, as per my earlier email, I went to that one, early, or as per below, if it was a email chain and it was like, really, you just didn't read 2 emails ago? This is my fault because why? I think that was a pretty effective twist of the knife.
I don't think I ever
I cannot believe that is not accurate. That cannot be accurate.
No, I mean, no, it can be, and for good reason, because I'm
charming? Is that what you're about to say?
Oh, God, no, the opposite. No, I was going to go very much the opposite. No, because I am annoyingly blunt. I think a lot of times if something was wrong, something hadn't been done, I think it would be hey, what happened with this? I would be very direct about, did you ever do this? That sort of thing. I don't think I ever...
You really think you had that same tone when you were as an associate when you were dealing with partners?
Oh, no. There's no passive aggressiveness with partners. There it was obsequiousness is the word you're looking for.
But those are the worst offenders. Those are the ones who can't be bothered to read all of the, all the emails from those who are below them or whatever. And you're like, we need a timeline. Cool story. There's been one sitting on your desk for 2 weeks. Was that one wrong? Was it different in some way? I don't understand what's going on.
I was pretty blunt with them too, not in a confrontational way always. Although, it depended on the relationship. I had one partner who I worked with for many, many years who our relationship was defined by the fact that I had no problem yelling at him and vice versa. And we got along great because we did not have any of those pretenses.
Interesting.
Other people I know who worked with the same partner had issues. They couldn't figure it out because they didn't have the ability to be direct, which is something that I think he valued a lot. So sometimes it works out. Different people work.
I also think
ways.
I gotta call you a little bit on this one. I do think that having that method available to you and still be considered a valued member of the team has no small part to do with the fact that you are a white heterosexual man, right? Like, women
sure.
have and people of color have a lot less access to those modes and still be seen as, collegial and jovial and a friend of the partner or whatever. It comes across like I'm a bitch if I'm direct or with people of color. There's lots of baggage to unpack there, and I think that as a white guy, you've got the full range of rhetorical devices available to you. And I think that actually is something that pisses me off when people talk about how like terrible passive aggressiveness is in the workplace and whatnot. Not that you did that, but I think that it's largely because that is a method that is available to all. It reads the same across a lot of different gender and ethnicities and whatnot. And I think that that's the reason why it is become increasingly popular within any sort of professional context. Which also, like, corollary to that, I realized this maybe about 5 or 6 years ago. I use probably too many, but I use emojis in professional correspondence all the time, and I think it's appropriate.
It's probably not, but we'll stick a pin in that for a second and just say, are you missing calls? Are you spread too thin? Interruptions kill your productivity, but clients demand a quick response. The U.S.-based professional receptionists at Smith AI help law firms screen new clients and schedule appointments by phone and website chat. Plus, Smith AI integrates with your software, including Clio and LawPay. Plans start at just $60 per month. Get a free trial at smith.ai. So we're back. So you use emojis in professional context. Now, granted, your profession right now is, making dick jokes about lawyers on the internet. So maybe it's okay here.
Yeah, no, I'm not just talking about when I worked at Above the Law, but previous to this as well. Yeah, I think that it also corresponded for me with an increase in sort of messaging programs being used at vendors and other law-related industries. But, when you're talking over chat with people, I think that going to a smiley face or a ha-ha face or something along those lines just makes sense and helps to, especially my last job before I started ATL, I worked with a lot of people in different offices that I had never met. And you're trying to build a relationship with someone and they may not understand the way that you're trying to say something. So throwing an emoji in there to be like, I mean this cutely, here's a smiley face, or like questioning, or shruggy emoticon to like make it clear this is the way that these words, which could be taken in a variety of different ways, is how I mean them in this context.
Yeah, I don't know. I certainly have used emoticons, the grandfather of the...
Sure, but I do think that like a lot of programs now just automatically convert them, right?
Yeah, I guess that may be true. Yeah, I've certainly done that before in rare instances where I'm trying to put no, I'm not really yelling on what would otherwise be a terse reading email. But yeah.
Well,
and I'm one of those people who doesn't actually have a problem with emojis. I just feel like you're taking it maybe just a bridge too far for me.
Well, I also think that before Above the Law, did you have many jobs that used messenger clients as their primary mode of communication?
No, it was always formal email.
Yeah, which I think is also different. But I do think, there's Slack, there's Messenger, there's Ping, there's all these different programs now, which is meant to sort of let employees be accessible if they're working remotely. People work from home, you work across offices and whatnot. And so you use these programs. And again, if you've never met someone and you've been on a project for 2 months together, you have to find a kind of shorthand way to make sure you understand what's going on.
Yeah. just got that new assignment, eggplant. Yeah.
I haven't used the eggplant emoji at work, so
Fair enough.
that's a step in the right direction.
Yeah. But yeah, that's interesting. So I will say, back to the passive-aggressive thing, one of my all-time favorite stories, and I love all the people
Please tell
involved
it.
in this story, but I got an email from a partner, I guess not a partner at the time, but a senior associate who was about to be a partner at the time, saying, hey, just like exasperatedly, after, a day after a thing was supposedly due, did you send the blah, blah, blah letter? And I went, yes, I did remember that. I did send the letter. Followed immediately by, why would you do that? And I was like, see, that wasn't cool. That was just not cool to begin this way.
They tricked you. They absolutely tricked you.
Yeah, that was not cool. But no, I have no problems with the people involved in that story. But it was, I've even told the person that story years later.
They're angry about the letter. They can't tell whether they're mad that you did it or didn't.
Yeah.
But either way, you probably did it wrong.
That
actually is probably good life advice. Joe Patrice probably did it wrong.
Ooh, that's...
I'm sorry, that was bitchy, but I had to go for it right there.
Yeah. But at least you were active-aggressive as opposed to
you
passive.
appreciate that, do you?
Yeah, I do.
Okay, well,
yeah.
that's good to know.
I mean,
Catalog.
I work with Ellie. I appreciate active-aggressive. But yeah. So what have we covered now? We've covered law firm mood and style. We've covered a brief, foray into the privilege issues involved with being white men, heterosexual men at work. We've talked about emojis. This has been a banner day.
Wide-ranging.
A wide-ranging day, considering we walked in with no particular agenda, but we're...
And we still don't have one, but here's something about the eggplant emoji. You ready?
Okay.
Well, it's not really about that, but one of the stories that I thought was interesting from this week, I don't know if you've heard, but at the recent law professor conference, AALS, at one of the panels, the Columbia dean said that one of the best ways for law school administrations that are looking to make
Only way, even.
Yeah, only way. Yeah, they did say that. Only way for law school deans or administrations to find out whether or not someone they're considering for a lateral move to their law school to know whether or not they have a history of sexual harassment is when Above the Law reports on it.
Yeah.
And I do a lot of that work, right?
That's true.
It was definitely something that I was, shocked by. And some of the social media traffic queried why law schools can't ask the applicants about these things. And there's a lot of confidentiality issues, frankly, when it comes down to it. So they're a little bit hamstrung about trying to get all the details out there. And I thought it was a really interesting thing, and it's something that I think that at Above the Law we try to cover as soon as we know about it.
Yeah, no, it was very gratifying
to
see that message come across, even though I don't do nearly as much of that work as you did. Although
you do a bunch of it.
We did a lot of the Yale issue from last year, which is still unresolved, but we just reported what we were hearing from it. A lot of that I was involved directly in the reporting work.
And
on
I actually
that.
wound up doing, because this kind of inspired me, I wound up doing kind of an omnibus post that was like, hey, here are the sort of Me Too, the professors that have been caught up in Me Too scandals, and providing links to all those stories that we've written, because there's not like an easy place to go. We don't have some sort of a subpage. It's like Me Too scandals at law schools. So I kind of created this post to collect all of the stories in one location so they're easier to find. And you had written a bunch of them. There was a bunch of stuff from 2017 that you had written, former dean, stuff like that. Okay, he's smiling. Like,
yeah.
I'm just
well, no, I mean, it's
always
always,
something we all participate in.
It's always heartening to hear your colleagues talk about how you've done such a fantastic job. So thank you.
You are very not welcome.
But no, that is a key thing, that we operate as something of a check upon these issues, largely because for whatever reason, people feel that they can't get into them. And that's been kind of the long-term problem in the Me Too issue, is that there have been a he said, she said thing that perennially leaves people with no ability to resolve issues and no recourse, and is discouraging. And we at Above Law have a capability. It's not like we just run with whatever random anonymous tip we hear.
Sure.
You know, we have standards and
Of course.
believe in reporting things out, but you know, we are a sounding board where people can tell their stories, and if we get something together, we can be a resource for schools and firms to avoid doing
Terrible things.
bad things again.
Yeah.
Which we had a story last year of a partner who lateraled to a new place for that new place to find out the reason they were lateraling was that there had been a problem at the first place. So,
yeah, I think one of the good parts about this job is being able to hold folks that don't feel like they have to be actually holding them accountable in some small way.
yeah. Well, we're recording this before you're going to hear it. So
That is generally how that works.
yeah, I mean, otherwise it's a tremendous strain on the editors. But but yeah, so as of now, and I'm willing to venture that this will still be true when this episode comes out, and if it's not, we can all be pleasantly surprised. There is a government shutdown, and we are staring down. It's for us right now. Well, by the time you hear this, it'll be less than a week before the federal courts will run out of money.
That sounds bad.
Yeah. There's already a plan in place for what they need to do if they do run out of money. But, yeah, we already have several members of the Department of Justice are working without pay right now. It's a situation that's only going to get worse over the next bit. And so we're, sending out our...
Yeah, I think it's been interesting, some of the reactions that the judges have had to the situation as well. I think you wrote something about this.
I did. Nice segue. Yes, I wrote about a judge who, basically, a lot of what's happening is that in the criminal cases, which obviously are the most difficult to, they're the most grave and serious.
Sure.
Those are moving forward. But to the extent the DOJ pursues civil actions, their strategy has been to file with judges, hey, there's a government shutdown, so let's have an indefinite stay of this case. And a couple of judges have gotten these and responded with nope, including one judge who referred to it as laughable that the government thinks that they can get out of this because they don't have any money. And his response was, this is not a policy issue. This is the abdication of the president and Congress to the extent Congress could theoretically override a veto if they got everyone together to fund the government.
Or if they voted on it,
to faithfully execute the laws. And his response was, given that is what is going on here, it is no different than if a private litigant walked into my room and said, you know what, I've decided to stop paying my attorneys. Give me some more time. And it's like, no, I would never do that. So why would I afford the government the same option? And
I think I read something too that during the last government shutdown, which admittedly is likely to be significantly shorter, the government had similarly requested extensions and delays in 16 instances, and each of them were soundly rejected. So it really isn't a surprise that this is how judges are reacting to the latest shutdown, particularly when it seems like a long shutdown is not something that the president is afraid of.
I mean, others have said, and I have a link to this in my post on this judge. Other commentators have pointed out that if you're a practitioner right now and you have a client who has a case, a civil case against the government, you probably should file that right now.
Yeah, you should.
There's a non-zero chance that you can win a default judgment here. Because the DOJ is certainly not in a position to fight back.
Yeah.
And if judges are unwilling to offer these stays,
absolutely.
This is your opportunity right now. If you slipped and fell in front of a mail in a post office, this is your time.
The time is now.
So yeah, that's going on. We feel very bad for all the AUSAs out there who are working without pay.
The other folks in other positions. But as it specifically relates to above the law,
I get it. Our audience,
I get it. I just,
On the other hand, AUSAs, they're going to find other jobs. Whenever they want to, they can.
Sure,
they
if you're an
can work
AUSA, you probably have the legal world is your oyster. Let's say.
So maybe we shouldn't feel that bad. Yeah, screw them.
I don't really mean that. But.
Yeah. Well. Yeah. Cool. Yeah. So, what else happened? Oh, I got in a fight with some like random right-wing trolls on the internet.
Oh, that must have been a good time. I remember the time that you told me that some right-wing troll had declared a fatwa on me.
Yes, that happened.
I don't even remember what the story was anymore, but I've only been at this job 3 years, mind you. But it made me feel like I was doing the right thing.
Yeah, no, you had a call out everyone should try to destroy Catherine Rubino from a radical anti-immigration group. So that was a thing you did. My issue this week was a former clerk. And by clerk, you think, wow, that great academic must be smart. But you've got to kind of also remember if they're clerking for high-end Republican judges, they, especially at the circuit level, you don't really know. They're probably just some random troll who was the top of their FedSoc group.
Sure. That does appear to be how the majority of
so you can't
jobs.
Yeah, and it's unfortunate because
seems like
when you're going around hiring, you're saying, "Ooh, this is a circuit clerk," but then you kind of realize they don't really know anything. Anyway, some random former clerk, and not just former clerk for Judge Ho, who even conservative law professors like Orrin Kerr have said Judge Ho's out of his gourd with some of these opinions he's writing. So he said a bunch of random stuff attacking his own school for doing pro bono work, which
seems inappropriate.
Yeah, which I said was wrong on, basically wrong, but I went into more detail about some of the statements that were designed to be misleading and inflammatory on this guy's part.
So a right-wing troll, you wrote about a right-wing troll, so no surprise actually that a bunch of trolls come after you, huh?
Yeah, no, and he tried to fight with me a few times after that on Twitter, and it was like comical. Like, because, I mean, fighting with these people on the internet it requires some degree of intestinal fortitude because they come at you like, and it's annoying, and they're obnoxious, and they kind of beat at you, and they have their buddies attack you, whatever. But I mean, if you actually have the wherewithal to go through it, it's really like fighting a toddler. I mean, it's just like they're not particularly smart or funny, and you can just
toddlers.
You can just flip everything on them, and like it's satisfying if you have an audience because of people who are kind of smart, because then they kind of keep back-channeling like, oh, my God. And it's useful, too, because I feel, especially in the legal world, these folks have professional reputations. And just building this record of how actually they aren't remotely smart enough to
hold the
positions they have is valuable in and of itself. So,
well, good on you.
Yeah, no, that was fun
this week.
Yeah, I mean, just fought back against some randos.
But
it's,
push back in every instance, right?
Yeah. So that's us.
That's been the week that was.
The week that was for this Thursday is when we record this. So, yeah, cool.
All righty.
Excellent. Yeah, you can tell this is one that was put together in emergency as we were like, are we done?
So, how about those?
There's no script here. This is
sports ball.
Sports. Yeah, we're very much doing we're like jazz musicians, but like really bad at jazz. There's no like good give or take.
That was another thing that happened recently.
Jazz?
No, Joe, sports ball.
Sports ball, yes.
Sports ball. Recently was the college football national championship.
That's true.
And Alabama got the snot beat out of that.
They did. And what's weird is like not in any way that, like on almost every individual play, you would have thought Alabama was winning, and then just not
at all. Yeah, no, I thought that was a pretty fun game to watch for those that have gotten a little tired of seeing Alabama dominant year in and year out.
And instead, it was just the other team that's been in 3 national championships.
You gotta take what you got, But I do think that
it's like watching Cravath be at the top of the list every year. Yeah, you're like,
oh. Now it's Oric.
What's this, King and Spalding?
Yeah. Who's Latham? But no, I think it's interesting. I do think that about halfway through, I was like, oh my gosh, are we watching the end of the dominance of Alabama? Which might be wishful thinking, but it was still fun to watch.
Cool. Yeah, that was legal in some way.
They have law schools?
Yeah. Alabama does.
Alabama does? Yeah. Count it.
Fair enough. All right. So with that, we're done. So, thank you for stepping in an emergency setting, which
Sure,
I'm
no
glad that you
problem.
agreed to my request, which was humble and in no way presumptive
Okay.
that you would be here.
It won't be in the future. I can guarantee that.
Yeah. And thank you all for listening. If you aren't subscribed to this show, and by that I mean if you just like randomly came across the show somehow, then you should subscribe to it. That way it gets sent to your various listening devices and you'll never miss another episode of, the pure content gold that is what we just did there. You should also give us reviews, stars, write something about it, explain how much you miss Ellie.
Oh, come on.
No,
I'm right.
yeah.
I'm in the room.
Yeah, fair enough. Anyway, but write those things. That helps us move up and the algorithms so that more people who are interested in hearing about law can see us. You should also follow The Jabot, which is Catherine's podcast.
Yeah.
Yeah. You should follow the other Legal Talk Network family of shows. You should follow us on Read Above the Law, obviously.
Course.
Follow us on
Obviously.
Twitter. I'm at Joseph Patrice. She's at Catherine1, spelled in the way she spells it.
Kathryn.
Yes, that version of Catherine, because there are.
That's true.
Multiple.
There's a lot of commonly accepted spellings of my first name,
Yeah,
but mine's the best.
sure, why not?
Okay.
Anyway, so with all that said, I think that's the end of this episode. Good job.
Bye.
Bye.
If you'd like more information about what you've heard today, please visit LegalTalkNetwork.com. You can also find us at AboveTheLaw.com, ATLRedline.com, iTunes, RSS, Twitter, and Facebook. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.